Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about some common misperceptions surrounding Florida non-compete agreements. So let's get right to it. Number one, I can't have a non-compete agreement in Florida because Florida is a right-to-work state. Utter nonsense. The right to work law simply prohibits a company from requiring its employees to pay union dues as a condition of their employment. The right to work law has absolutely nothing to do with non-compete agreements and does not serve as a defense to the enforcement of such an agreement. Number two, Florida disfavors non-compete agreements. I have heard this time and time again. I have heard people say, well, those things don't hold up. Indeed, they most certainly do. And if you look at this from a comparative perspective across the country, Florida is arguably the single most pro-enforcement state out there. So non-compete agreements are more likely to be enforced and enforced aggressively in Florida than any other state in the country. If people are giving you this sort of BS conventional wisdom about Florida disfavoring non-compete agreements or those agreements don't hold up, you should reject that out of hand. That is terrible and very dangerous advice. Number three, scope. The non-compete agreement doesn't have a time limit on it, or it's written for the entire world, or it says it's 10 years long, or it says it's the entire country, but I only worked in South Florida. It'll never hold up. Again, nonsense. There are some states in which if the non-compete agreement is written in a dramatically overbroad fashion like that, those states simply will not enforce it. Florida is not one of those states. So if you have a non-compete agreement in Florida and it's written in a manner that is entirely unreasonable with respect to geographic or temporal scope, Florida courts will simply strike that out and put something in that they think is reasonable. So being overbroad in terms of geographic or temporal scope, it is no defense to the enforceability of a non-compete agreement under Florida law. Number four, I can't have a non-compete agreement. I'm a doctor. Well, in Florida, that doesn't matter. There are some states that have actually passed legislation saying you cannot enforce a non-compete agreement against physicians. Unfortunately for doctors in Florida, Florida is not one of those states. So if you are a physician and you sign a non-compete agreement, you need to understand that it will most likely be enforced against you in some fashion. Number five, I was forced to sign a non-compete agreement, but I wasn't given any additional compensation. Again, nonsense. It doesn't matter. Some states operate differently, but again, in Florida, continued employment in and of itself is considered sufficient consideration to justify the use and enforcement of a non-compete agreement. Number six, in connection with the previous one, you were forced to sign a non-compete agreement. So many people have called me and said, I was forced to sign this. I signed against my will. I signed under protest. This can't possibly be enforced against me. Again, nonsense. It doesn't matter if you're forced to sign it under Florida law. It's still going to be enforced against you. Number seven, they breached it first. Well, sometimes that checks out as a defense, but more and more companies are including provisions in the contracts that say all of the different obligations shall exist independent of one another. The upshot of that is a failure to pay you compensation, a failure to pay you bonuses, commissions, etc., does not have any effect on the non-compete covenants. So again, prior breach, not necessarily a defense under Florida law. Let's see if I can recap these in the correct order, okay? Number one, Florida's a right-to-work state. Nonsense. No, it isn't. Number two, these things will never hold up. They're generally disfavored. Again, nonsense. Not under Florida law. Number three, it's too broad in terms of geography. It's too long in terms of time. Doesn't matter. Florida courts will simply fashion something reasonable. Number four, I can't have a non-compete. I'm a doctor. Again, doesn't matter. Florida courts will still enforce it. Number five, I wasn't given any additional compensation, any bonus, anything in exchange for my non-compete. Doesn't matter. Florida courts will still enforce it. Number six, I was forced to sign. I signed against my will. I signed under protest. Doesn't matter. It'll still be enforced against you. And number seven, they breached it first. Might not necessarily matter depending on how the contract is written. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question or a concern about a non-compete agreement, whether it's in connection with employment, whether it's in connection with the sale of a business, whether it's in connection with a commercial lease, regardless of your industry, please feel free to give me a call. I'd be happy to talk with you. Have a good day.